Question 1. Rules of evidence. During an emergency response where multiple areas are impacted, a defense attorney objects to the admission of a police report under the hearsay rule. The prosecution argues that the report is admissible under the public records exception. The report contains both factual observations of officers at the scene and conclusions drawn by a forensic analyst who was not present at trial. How should the court rule? Objection, and why? A. The entire report is inadmissible because it constitutes hearsay and does not fall within any exception. B. The factual observations of the officers are admissible, but the forensic analyst's conclusions should be excluded as testimonial hearsay. C. The entire report is admissible under the business records exception to the hearsay rule. D. The forensic analyst's conclusions are admissible, but the factual observations of officers must be excluded. Objective interpretations. Answer. B. The factual observations of the officers are admissible, but the forensic analyst's conclusions should be excluded as testimonial hearsay. Explanation. The federal rules of evidence 3 govern hearsay and its exceptions. Under 3803(8) public records exception, factual findings from public offices or agencies may be admissible if they involve matters observed by a public official under duty to report. However, in Crawford v. Washington, 2004, the U.S. Supreme Court held that testimonial hearsay statements made for the purpose of litigation is inadmissible unless the declarant is unavailable and the defendant had prior opportunity to cross-examine them. Option is incorrect because public records containing factual observations by officers may be admissible under 3803(8). Option B is correct because factual observations by law enforcement officers can be admitted, but conclusions from forensic analyst who is not present at trial violate Crawford. Option C is incorrect because the business records exception 3803(6) does not apply to law enforcement reports in criminal cases. Option D is incorrect because forensic conclusions, if considered testimonial, cannot be admitted without cross-examination. Thus, the court should admit only the factual observations but exclude the forensic analyst's conclusions. Question 2. Cross-examination. In a situation where formal requirements conflict with trial strategy, a defense attorney seeks to impeach a prosecution witness using prior inconsistent statements the witness made. A sworn statement during a deposition that contradicts their testimony at trial. The prosecution objects, arguing that the statement is inadmissible because the defense did not provide prior notice. How should the court rule? A. The prior inconsistent statement is admissible for impeachment purposes and no prior notice is required. B. The statement is inadmissible because impeachment evidence requires disclosure before trial. C. The statement is admissible only if the witness acknowledges the inconsistency on direct examination. D. The statement is inadmissible unless the defense establishes a hearsay exception. Answer A. The prior inconsistent statement is admissible for impeachment purposes and no prior notice is required. Explanation. Under 3613, prior statement of witnesses an attorney may use a prior inconsistent statement to impeach a witness without providing advance notice to the opposing party. The rule requires only that the witness be given an opportunity to explain or deny the statement at some point in the proceedings. The U.S. Supreme Court case Harris v. New York, 1971, clarified that prior inconsistent statements can be used for impeachment even if they would be inadmissible as substantive evidence. Option is correct because 3613 does not impose a prior notice requirement. The attorney only needs to allow the witness to explain or deny the statement. Option B is incorrect because impeachment evidence does not require pretrial disclosure unless mandated by court order or a discovery rule. Option C is incorrect because a witness's acknowledgement on direct examination is not prerequisite for impeachment. Option D is incorrect because impeachment does not require meeting hearsay exception. It is not being used for the truth of the matter asserted. Thus, the court should allow the defense to use the prior inconsistent statement for impeachment. Question 3. Closing arguments. While examining inconsistencies across various units, a prosecutor delivers a closing argument that emphasizes the defendant's decision not to testify, suggesting that an innocent person would have spoken in their defense. The defense objects, arguing that the comment violates the defendant's Fifth Amendment rights. How should the court rule on this objection? A. Sustain the objection because the prosecutor's comment violates the defendant's right to remain silent under the Fifth Amendment. B. Overrule the objection because the jury is allowed to consider the defendant's silence as part of the overall evidence. C. Sustain the objection only if the defense made an explicit request before trial to prohibit such comments. D. Overrule the objection because closing arguments are not bound by the evidentiary restrictions as testimony. Answer A. Sustain the objection because the prosecutor's comment violates the defendant's right to remain silent under the Fifth Amendment. Explanation. Under Griffin v. California, 1965, the U.S. Supreme Court held that prosecutor cannot comment on defendant's failure to testify because it violates the Fifth Amendment's protection against self-incrimination. Such comments unfairly suggest guilt based on silence rather than evidence. Option is correct because Griffin establishes that such prosecutorial remarks are unconstitutional. Option B is incorrect because juries are expressly instructed not to consider defendant's silence as evidence of guilt. Option C is incorrect because no pretrial motion is required to invoke the Fifth Amendment's protection against prosecutorial comment on silence. Option D is incorrect because closing arguments, while more flexible than witness testimony, are still subject to constitutional constraints. Thus, the objection should be sustained, and the court may issue curative instruction or declare mistrial if the comment was prejudicial. Question 4. During a comprehensive review of a process that needs improvement in the cross-examination phase of a trial, an attorney is attempting to impeach an opposing witness who has provided inconsistent statements regarding a key piece of evidence. The witness, during a deposition, claimed that they had never seen the defendant before the incident, but during trial they now assert that they had prior interaction with the defendant 1 week before alleged crime. The attorney wishes to introduce the deposition testimony to contradict the witness's trial statement. Under the federal rules of evidence, which of the following would be the best method to impeach the witness's credibility? A. Ask the witness whether they remember making the prior inconsistent statement and, if denied, present the deposition transcript to refresh their recollection. B. Introduce the prior inconsistent statement as substantive evidence without allowing the witness to explain the inconsistency. C. Call another witness to testify about what they believe the witness intended to say during the deposition. D. Argue to the judge that the witness's inconsistent testimony should to immediate dismissal of their entire testimony. Answer A. Ask the witness whether they remember making the prior inconsistent statement and, if denied, present the deposition transcript to refresh their recollection. Explanation. Under Rule 613B of the Federal Rules of Evidence, an attorney may introduce a prior inconsistent statement to impeach a witness, but the witness must be given an opportunity to explain or deny the statement. If the witness does not recall or disputes inconsistency, the attorney may use the deposition transcript to refresh recollection or impeach credibility. Option B is incorrect because under the free, a prior inconsistent statement is generally not admissible as substantive evidence unless it falls within an exception such as being given under oath in a prior proceeding under Rule 801D1A. Option C is incorrect because another witness cannot testify about what they believe the original witness meant. It would be inadmissible speculation. Option D is incorrect because inconsistency does not automatically lead to dismissal of all testimony. Rather, it affects credibility, which is for the jury to assess. Question 5. While investigating inconsistencies across various units in a multi-defendant criminal trial, a defense attorney wants to prevent the prosecution from introducing a piece of evidence obtained through a police interrogation where the defendant was not advised of their Miranda rights. However, the prosecution argues that the statement was voluntarily made in a non-custodial setting. Which of the following is the strongest argument for the attorney to exclude the evidence? A. The statement should be excluded because any interaction between police and a suspect automatically requires Miranda warnings. B. The statement should be excluded because the defendant subjectively believed they were in custody even if a reasonable person would not feel the same way. C. The statement should be excluded if the circumstances suggest that a reasonable person in the defendant's position would have felt they were in custody and thus entitled Miranda warnings. D. The statement should be excluded because Miranda warnings must be provided whenever the police ask any questions related to crime. Answer C. The statement should be excluded if the circumstances suggest that a reasonable person in the defendant's position would have felt they were in custody and thus entitled to Miranda warnings. Explanation. Under Miranda v. Arizona, 1966, law enforcement must inform suspect of their Miranda rights before conducting custodial interrogation. The key issue is whether a reasonable person in the defendant's position would have felt they were deprived of freedom to the extent associated with formal arrest. Berkheimer v. McCarthy 1984. Option is incorrect because not all interactions with police require Miranda warnings. Only those where the suspect is in custody and subject to interrogation. Option B is incorrect because the suspect's subjective belief is not the legal standard. If the test is objective, Option D is incorrect because police can ask investigatory questions without providing Miranda warnings if the suspect is not in custody. Question 6. During an emergency response where multiple areas are impacted by a natural disaster, a lawsuit is filed against a city government alleging negligence in its evacuation efforts. The plaintiff's attorney intends to introduce statements made by city officials to the press as evidence of liability. The defense objects arguing that the statements constitute hearsay. Which of the following best describes how the court should rule? A. The statements are inadmissible hearsay because they were made outside of court and are being used for the truth of the matter asserted. B. The statements are admissible as party opponent admissions under the federal rules of evidence. C. The statements are inadmissible because official government statements cannot be used as evidence in civil cases. D. The statements are admissible only if the official personally testifies in court and affirms the statements. Answer. B. The statements are admissible as party opponent admissions under the federal rules of evidence. Explanation. Under 3801 D2, statements made by a party's representative, such as government official, can qualify as party opponent admissions and are not considered hearsay. Option is incorrect because statements made by party opponent are specifically exempt from the hearsay rule. Option C is incorrect because there is no blanket rule prohibiting official government statements in civil cases. Option D is incorrect because party opponent admissions do not require the declarant to testify at trial. Question 7. In a case where multiple parties have different objectives in a wrongful death lawsuit, the plaintiff's attorney seeks to introduce evidence of the deceased's past medical expenses to prove damages. The defense objects arguing that the expenses were paid by the decedent's insurance company. How should the court rule? A. The evidence is admissible because past medical expenses are relevant to determining damages, regardless of who paid them. B. The evidence is inadmissible because any expenses covered by insurance should not be considered. C. The evidence is admissible only if the plaintiff can prove the decedent personally paid for all expenses out of pocket. D. The evidence is inadmissible because the jury should not consider any expenses already paid by third parties. Answer A. The evidence is admissible because past medical expenses are relevant to determining damages, regardless of who paid them. Explanation. This issue relates to the collateral source rule, which generally prohibits defendants from introducing evidence that a plaintiff's losses were covered by insurance. Courts recognize that defendants should not benefit from third-party payments to plaintiffs. See Restatement, 2nd of Torts SS 920. Option B is incorrect because courts typically allow evidence of medical expenses incurred regardless of insurance. Option C is incorrect because personal payment is not required for damages to be recoverable. Option D is incorrect because the jury should determine damages based on the actual loss suffered, even if insurance covered it. Question 8. During a medical malpractice trial, the plaintiff's attorney calls an expert witness to testify about the standard of care. The defense objects arguing that the expert lacks experience in the specific medical field relevant to the case. Under the federal rules of evidence, which of the following factors is most important in determining whether the expert witness's testimony should be admitted? A. Whether the expert has direct experience performing the exact procedure at issue in the case. B. Whether the expert's qualifications, including education and professional experience, establish them as knowledgeable in the broader field of medicine. C. Whether the expert personally knows the defendant and has observed their medical practice. D. Whether the expert has previously testified for the plaintiff in similar cases. Answer B. Whether the expert's qualifications, including education and professional experience, establish them as knowledgeable in the broader field of medicine. Explanation. Under 3702, an expert witness must have scientific, technical, or specialized knowledge that will assist the trier of fact. The key factor is whether their education, experience, and training are relevant to the case at hand, not whether they have performed the exact procedure. Option is incorrect because an expert need not have performed the specific procedure to testify about the applicable standard of care. Option C is incorrect because personal acquaintance with the defendant is not prerequisite for expert testimony. Option D is incorrect because past testimony for the plaintiff does not determine admissibility. Question 9. A prosecutor is cross-examining a criminal defendant about prior convictions. The defense objects arguing that this unfairly prejudices the jury. Under what circumstances would the court likely allow questioning about the defendant's prior convictions? A. If the prior conviction is for crime involving dishonesty or false statements and is less than 10 years old. B. If the prior conviction is for any type of crime, regardless of how long ago it occurred. C. If the defendant testifies, all prior convictions automatically become admissible. D. If the prior conviction resulted in sentence of at least 1 year, it must be admitted. Answer A. If the prior conviction is for a crime involving dishonesty or false statements and is less than 10 years old. Explanation. Under 3609, prior convictions may be admitted to impeach a witness if the crime involved dishonesty or false statements or it was a felony subject to a balancing test under 3403. Convictions older than 10 years are generally inadmissible unless the probative value outweighs the prejudicial effect. Option B is incorrect because some crimes, e.g., minor offences, are not automatically admissible. Option C is incorrect because testifying does not open the door to all prior convictions. Option D is incorrect because a 1-year sentence alone does not determine admissibility. Question 10. During closing arguments, an attorney makes an emotional appeal, telling the jury that the defendant is a dangerous individual who should never walk free again. Even though the case is civil dispute, the opposing counsel objects. How should the judge rule? A. Sustain the objection, as the argument improperly appeals to emotion rather than facts. B. Overrule the objection, as attorneys are given broad latitude during closing arguments. C. Sustain the objection, unless the attorney can provide supporting evidence for their claim. D. Overrule the objection, because closing arguments do not have to be based on the evidence presented. Answer A. Sustain the objection, as the argument improperly appeals to emotion rather than facts. Explanation. Closing arguments must be based on evidence presented during trial. Emotional appeals that are not tied to the facts of the case are considered improper advocacy and can be grounds for reversal on appeal. United States v. Young, 1985. Option B is incorrect because broad latitude does not extend to improper emotional appeals. Option C is incorrect because closing arguments should not introduce new evidence. Option D is incorrect because all arguments must be based on trial evidence. Question 11. During jury deliberations, a juror uses their phone to search for background information about the legal issues in the case. Another juror reports this to the judge. What is the most appropriate action for the judge to take? A. Declare a mistrial due to juror misconduct. B. Question the juror to determine the extent of the misconduct and decide on appropriate action. C. Instruct the jury to ignore the information but allow deliberations to continue. D. Replace the juror with an alternate and continue deliberations without further inquiry. Answer B. Question the juror to determine the extent of the misconduct and decide on appropriate action. Explanation. Jurors are strictly prohibited from conducting independent research. Rema v. United States, 1954. However, the judge must first determine the extent of the misconduct before deciding whether a mistrial or another remedy is necessary. Option is incorrect because a mistrial is not automatic. Prejudice must be evaluated. Option C is incorrect because simply instructing the jury to ignore information may not be sufficient. Option D is incorrect because the judge must first assess the impact of the misconduct. Question 12. An attorney wishes to introduce a handwritten contract into evidence, but the original document has been lost. Under the best evidence rule, what must the attorney do to admit a copy or secondary evidence? A. Prove that the original was lost or destroyed in good faith and provide a reliable duplicate. B. Prove that the opposing party has the original document and refuses to produce it. C. Show that the copy is more convenient to use than the original. D. Demonstrate that the witness remembers the exact wording of the contract. Answer A. Prove that the original was lost or destroyed in good faith and provide a reliable duplicate. Explanation. Under 31002-1004, the best evidence rule requires the original document unless it is lost or destroyed without bad faith. If the original is unavailable, a duplicate or other secondary evidence may be admitted. Option B is incorrect because even if the opposing party has the document, a formal motion to compel production is required. Option C is incorrect because convenience is not a valid reason for excluding the original. Option D is incorrect because oral testimony is not a substitute unless the document is completely unavailable. Question 13. A judge allows a witness to remain in the courtroom after testifying even though a rule of sequestration was requested. What is the likely justification for this decision? A. The witness is a party or representative of a party and thus exempt from sequestration. B. The rule of sequestration only applies to expert witnesses. C. Once a witness has testified, they cannot influence other witnesses. D. Sequestration is only required in criminal trials, not civil cases. Answer A. The witness is a party or representative of a party and thus exempt from sequestration. Explanation. Under 3615, witnesses may be sequestered, excluded from the courtroom except for a party to the case or a party's designated representative, e.g. corporate officers in business litigation. Question 14. During a cross-examination, the opposing attorney objects, arguing that the question is misleading and assumes facts not in evidence. What is the best response for the questioning attorney to make to persuade the judge to overrule the objection? A. Your Honor, the witness's prior testimony provided enough context to support this question. B. Your Honor, leading questions are allowed in cross-examinations. C. Your Honor, I will rephrase to clarify the foundation of my question. D. Your Honor, this question is necessary to expose contradictions in the witness's statement. Answer. C. Your Honor, I will rephrase to clarify the foundation of my question. Explanation. When question is objected to for being misleading or assuming facts not in evidence, the best response is to clarify the foundation or rephrase the question to ensure it aligns with established testimony. Option is incorrect because the opposing attorney may argue that the prior testimony does not sufficiently support the question. Option B is misleading because while leading questions are permitted in cross-examinations, they cannot mistake facts or assume unproven details. Option D is incorrect because an argument about contradictions does not justify misleading question. Question 15. A defense attorney wants to introduce evidence of a plaintiff's prior lawsuit history to suggest pattern of frivolous litigation. The plaintiff's attorney objects. How should the judge rule? A. Sustain the objection because prior lawsuits are generally relevant to the current case. B. Overrule the objection because history of litigation is always admissible. C. Sustain the objection unless the defense can prove the prior lawsuits were fraudulent. D. Overrule the objection if the evidence shows pattern of abuse of the legal system. Answer. D. Overrule the objection if the evidence shows a pattern of abuse of the legal system. Explanation. Evidence of prior lawsuits is not automatically admissible but may be allowed if it demonstrates a pattern of bad faith litigation or an abuse of the legal system. Courts weigh probative value against potential prejudice. 403. Option is incorrect because such evidence can be relevant if it shows fraudulent or habitual legal claims. Option B is incorrect because prior lawsuits are not always admissible and they must be relevant. Option C is incorrect because the defense does not need to prove fraud. Only that there is pattern of questionable lawsuits. Question 16. During jury selection, an attorney uses peremptory challenges to exclude multiple jurors who belong to a racial minority group. The opposing counsel raises a Batson challenge. What must the attorney do to defend their strikes? A. Demonstrate a race-neutral reason for each peremptory strike. B. Argue that peremptory challenges are discretionary and not subject to review. C. Prove that the opposing counsel is also striking jurors of a different race. D. Show that the final jury includes some members of the excluded racial group. Answer A. Demonstrate a race-neutral reason for each peremptory strike. Explanation. Under Batson v. Kentucky 1986, a party cannot use peremptory challenges solely based on race. If a Batson challenge is raised, the party must provide a race-neutral justification for each strike. Option B is incorrect because peremptory challenges can be reviewed if challenged under Batson. Option C is incorrect because the opposing party's strikes are irrelevant to the legitimacy of the first party's challenges. Option D is incorrect because the final jury composition does not excuse race-based strikes. Question 17. A witness is called to testify about an incident they observed. During questioning, the witness struggles to recall details. What is the best method for refreshing the witness's memory? A. Show the witness written statement they previously made and allow them to review it. B. Provide the witness with notes summarizing the attorney's interpretation of the event. C. Read portions of the witness's deposition aloud and ask leading questions. D. Have another witness testify about what the first witness previously said. Answer: A. Show the witness a written statement they previously made and allow them to review explanation. Under 3612, an attorney may use a document or other aid to refresh a witness's recollection, but the witness must then testify from their memory rather than simply reading the document aloud. Option B is incorrect because an attorney's notes are not proper memory aid under 3612. Option C is incorrect because leading questions are typically not allowed during direct examination. Option D is incorrect because another witness cannot testify about what witness previously said unless it meets hearsay exceptions. Question 18. An attorney attempts to introduce a police report as evidence in a civil trial. The opposing counsel objects, arguing that it is hearsay. Under what circumstances could the judge admit the report? A. If the report is a public record and the officer is unavailable to testify. B. If the report contains only witness statements and no officer observations. C. If the plaintiff personally obtained a copy of the report from the police station. D. If the report is handwritten rather than typed. Answer: A. If the report is a public record and the officer is unavailable to testify. Explanation: under 803(8), public records and reports are an exception to hearsay if they contain observations made by public officials within the scope of their duties. If the officer is unavailable, the report may still be admissible. Option B is incorrect because witness statements in a police report are hearsay within hearsay and require their own exception. Option C is incorrect because how the plaintiff obtained the report is irrelevant to admissibility. Option D is incorrect because format, handwritten versus typed, does not impact hearsay exceptions. Question 19. A judge allows an attorney to use demonstrative evidence during closing arguments. The opposing counsel objects, arguing that the exhibit was not admitted during trial. How should the judge rule? A. Overrule the objection as demonstrative evidence can be used if it fairly represents the trial evidence. B. Sustain the objection as only admitted evidence can be referenced during closing arguments. C. Overrule the objection as attorneys have broad discretion during closing. D. Sustain the objection unless the jury specifically requests to see the exhibit. Answer: A. Overrule the objection as demonstrative evidence can be used if it fairly represents the trial evidence. Explanation: demonstrative evidence does not need to be admitted into evidence as long as it accurately represents trial evidence and is used to aid jury understanding. Option B is incorrect because courts allow visual aids to summarize evidence. Option C is incorrect because closing arguments are not unlimited. Evidence must be fairly represented. Option D is incorrect because jury requests do not determine admissibility. Question 20. In a scenario where efficiency decreases across multiple departments due to inconsistent communication, what legal strategies can be employed to ensure contractual obligations are met while reducing potential disputes? A. Implementing stricter penalty clauses to enforce compliance. B. Revising contracts to include clear communication protocols and dispute resolution mechanisms. C. Shifting liability to third-party intermediaries responsible for communication. D. Relying on verbal agreements and informal resolutions to maintain flexibility. Answer: B. Revising contracts to include clearer communication protocols and dispute resolution mechanisms. Explanation: efficiency issues arising from inconsistent communication can lead to breaches of contract and legal disputes. The best approach is to proactively modify contracts to define clear communication procedures between departments, alternative dispute resolution, other methods, such as mediation or arbitration, timelines for issue resolution. Option is incorrect because penalty clauses alone do not solve communication breakdowns. Option C is incorrect because shifting liability may increase legal complications. Option D is incorrect because verbal agreements are unenforceable in many business contexts. Question 21. During a major transformation where existing methods of documentation are being replaced by digital records, what legal considerations should be prioritized to ensure compliance with data protection laws? A. Implementing encryption and secure access measures while maintaining audit trails. B. Allowing open access to records to ensure transparency and efficiency. C. Destroying all paper records immediately after digitization to prevent duplication. D. Restricting digital record access to a single administrative entity to prevent leaks. Answer: A. Implementing encryption and secure access measures while maintaining audit trails. Explanation: transitioning from physical to digital records requires compliance with data privacy laws such as GDPR, HIPAA, or industry-specific regulations. Best practices include encryption to protect sensitive information, controlled access to limit unauthorized use, audit trails to track modifications and access. Option B is incorrect because open access may violate privacy laws. Option C is incorrect because destroying records prematurely may lead to non-compliance. Option D is incorrect because a single administrative entity creates a single point of failure. Question 22. In a case where multiple parties have different objectives in a contract negotiation, what strategy is most effective in ensuring a mutually beneficial agreement? A. Using an interest-based negotiation approach to find common ground. B. Focusing solely on securing the most favorable terms for your client. C. Avoiding detailed discussions to prevent unnecessary disputes. D. Relying on past agreements as a model without adapting to current needs. Answer A. Using an interest-based negotiation approach to find common ground. Explanation. When multiple parties have conflicting interests, the most effective approach is interest-based negotiation, which focuses on understanding each party's core needs, creating flexible solutions that align with mutual goals, avoiding rigid positional bargaining. Option B is incorrect because one-sided negotiation often leads to future disputes. Option C is incorrect because lack of discussion increases the risk of misinterpretation. Option D is incorrect because past agreements may not reflect current legal and business realities. Question 23. While analyzing the root causes of sequential problems in a legal compliance program, what key factors should be examined to prevent recurring violations? A. The clarity and accessibility of compliance policies. B. The number of compliance officers available. C. The frequency of unrelated disputes in other departments. D. The ability of employees to memorize regulations. Answer A. The clarity and accessibility of compliance policies. Explanation. Recurring compliance violations often stem from unclear or inaccessible policies rather than a lack of personnel or memory retention. Key solutions include simplifying legal language in compliance manuals, providing regular training and easy access to policy documents, implementing monitoring tools to track violations. Option B is incorrect because adding compliance officers does not fix policy clarity. Option C is incorrect because disputes in other departments are not directly related. Option D is incorrect because memorization is not the core issue. Understanding and access are. Question 24. When improving a process that shows unexpected results in a legal dispute resolution system, what approach ensures the most effective long-term outcome? A. Reviewing past case resolutions and identifying common bottlenecks. B. Applying a one-size-fits-all approach to speed up cases. C. Relying solely on AI-driven automation without human oversight. D. Eliminating mediation and focusing only on litigation. Answer A. Reviewing past case resolutions and identifying common bottlenecks. Explanation. Legal dispute systems can be improved by analyzing past cases to identify delays caused by procedural inefficiencies, repetitive errors in documentation or case management, gaps in legal frameworks that lead to inconsistencies. Option B is incorrect because a one-size-fits-all approach ignores case-specific nuances. Option C is incorrect because AI cannot replace legal judgment entirely. Option D is incorrect because mediation is often faster and more cost-effective. Question 25. During the introduction of new methods where coordination between legal teams and external partners is required, what is the most effective way to ensure smooth collaboration? A. Establishing clear roles, responsibilities, and escalation procedures in contracts. B. Relying on informal agreements to maintain flexibility. C. Minimizing direct communication to avoid conflicts. D. Allowing each team to operate independently without oversight. Answer A. Establishing clear roles, responsibilities, and escalation procedures in contracts. Explanation. Effective coordination between legal teams and external partners requires well-defined contractual agreements that specify roles and responsibilities to prevent overlap or gaps, communication protocols to address disputes early, escalation procedures to resolve conflicts efficiently. Option B is incorrect because informal agreements lack legal enforceability. Option C is incorrect because avoiding communication leads to misalignment. Option D is incorrect because independent operation may cause duplication of work. Question 26. When scaling up operations that experience significant contractual risks, what preventive measures should be taken to minimize legal exposure? A. Implementing standardized contracts with clear risk allocation clauses. B. Focusing on verbal agreements to expedite business growth. C. Eliminating contract audits to reduce administrative burden. D. Relying on a single governing law for all international agreements. Answer A. Implementing standardized contracts with clear risk allocation clauses. Explanation. Scaling operations introduces new contractual risks, such as liability disputes, breach of contract issues, and compliance concerns. Standardized contracts help by clearly defining risk allocation between parties, ensuring uniform legal language across agreements, providing dispute resolution mechanisms in case of conflicts. Option B is incorrect because verbal agreements are unenforceable and increase risk. Option C is incorrect because eliminating contract audits increases undetected legal exposure. Option D is incorrect because international agreements often require multiple jurisdictions for compliance. Question 27. During an emergency response where multiple areas are impacted by sudden legal changes, how should an organization ensure compliance while maintaining business continuity? A. Establishing a crisis management team with legal oversight. B. Halting all operations until regulatory authorities provide clarity. C. Relying solely on existing policies without adaptation. D. Deferring compliance decisions until after the emergency subsides. Answer A. Establishing a crisis management team with legal oversight. Explanation. In emergency situations, rapid legal compliance is necessary to avoid penalties or liabilities. The crisis management team ensures real-time assessment of legal changes, adaptation of policies and procedures, business continuity while minimizing legal exposure. Option B is incorrect because halting operations can cause financial losses. Option C is incorrect because existing policies may not address new regulations. Option D is incorrect because delaying compliance can lead to violations and penalties. Question 28. In an environment where different components must interact across multiple jurisdictions, what is the best approach to managing compliance risks? A. Creating a jurisdiction-specific legal compliance framework. B. Applying a single set of laws universally across all regions. C. Avoiding expansion into areas with complex legal requirements. D. Delegating compliance responsibility to third-party vendors. Answer A. Creating a jurisdiction-specific legal compliance framework. Explanation. Operating across multiple jurisdictions requires tailored compliance strategies that address local regulations and enforcement mechanisms, variations in contract law, employment policies, and tax laws, data privacy differences such as DDR versus as regulations. Option B is incorrect because legal systems vary significantly by region. Option C is incorrect because avoiding expansion limits business growth opportunities. Option D is incorrect because third-party vendors may not assume full legal responsibility. Question 29. While updating traditional approaches where interconnections between legal teams and departments are weak, what strategy improves coordination and compliance? A. Developing cross-functional policies that integrate legal and governance. B. Keeping legal and departments separate to maintain specialization. C. Outsourcing audit-related compliance matters to external consultants. D. Eliminating regulatory concerns by reducing data collection efforts. Answer A. Developing cross-functional policies that integrate legal and governance. Explanation. Legal and teams must collaborate to ensure cybersecurity, data privacy, and regulatory compliance. The cross-functional approach includes defining data protection policies aligned with legal frameworks, ensuring its systems comply with laws such as DDR or HIPAA, establishing response protocols for cybersecurity incidents. Option B is incorrect because separation creates gaps in compliance enforcement. Option C is incorrect because external consultants may lack deep internal knowledge. Option D is incorrect because reducing data collection may harm business intelligence. Question 30. During a seamless transition where continuity must be maintained, what is the best approach to handle contractual obligations while adapting to new legal requirements? A. Conducting a full contract review and implementing necessary amendments. B. Continuing to operate under old contracts until issues arise. C. Relying on verbal commitments to address potential conflicts. D. Automatically terminating existing agreements to start fresh. Answer A. Conducting a full contract review and implementing necessary amendments. Explanation. Legal transitions such as mergers, acquisitions, or regulatory shifts require proactive contract management to avoid breaches. Best practices include reviewing all active contracts for compliance gaps, negotiating amendments to align with new legal standards, ensuring uninterrupted service and financial obligations. Option B is incorrect because outdated contracts can lead to disputes. Option C is incorrect because verbal commitments are not legally enforceable. Option D is incorrect because terminating contracts disrupts business operations.